McCarthy, for the sake of clarity, tell me, when were the merits of the underlying order ever litigated?
Again, are we speaking about your present motion or the previous motion? I don't have the power to vacate or reconsider if that's not the request in your present motion.
Well, you're also beyond, because the license was, I believe, suspended improperly, and the order that suspended it is a void order. So we seem to be going on this circular dance when the facts are pretty clear. And I'll recitate the facts that what I now see, because since I went and did a public records request and a request for production of documents, the state of Florida opened up Miss Smallwood's file so I could see everything. And what's interesting is the case began, I guess, in North Carolina back in 1993, and it was subsequently, I guess, moved to Leon County, Florida in 1994. What did not happen between 93 and 94 was a service of process. And the rule, as we know, which has been in effect for some time, was that the original complaint, the initial complaint, was not served within 120 days. The summons and complaint within 120 days. The court had a couple of options, one of which at the time would have been that they've had to dismiss the case. They didn't do that. It wasn't served until 1999, which would be beyond the 120 days for service of process. SO2D 711,0, where it says that an action be dismissed without prejudice where service is not made upon a defendant within 120 days after the initial pleading, where there is no showing of good cause for the delay. And as we look at the clerk's record, we see that that did not happen. So I'll just say that the court erred in not dismissing the case at that point. We go further. Because it doesn't show that there was a good cause for failure to serve the defendant within 120 days,